Heightened tensions in the Strait of Hormuz, legal considerations for charter parties. 1. Strategic importance of Hormuz amid recent conflict. Following the June 13, 2025 escalation in hostilities between Israel and Iran, including reciprocal missile and airstrikes, the Strait of Hormuz has become the most closely watched maritime corridor in the world. As the narrow maritime gateway connecting the Persian Gulf to the open sea, it facilitates approximately 35% of the world's seaborne oil exports. At its narrowest, it spans just 22 nautical miles, making it a choke point of global significance. The heightened conflict has triggered official advisories from several governments, such as the UK and Greece, urging shipping operators to avoid the Gulf of Aden and register voyages, reflecting deep maritime anxiety. Amid this tension, shipowners are exercising extreme caution about deploying vessels through Hormuz. 2. Navigational rights and authority disputes. Under the 1982 UN Convention on the Law of the Sea, UNCLOS, vessels on the high seas and in exclusive economic zones enjoy transit passage through such vital straits. However, Iran, not party to UNCLOS, disputes whether innocent or transit passage applies to international vessels in the strait, challenging assumptions that these rights are part of customary international law. This legal schism between UNCLOS signatories and Iran creates uncertainty about navigation regulations in the strait. 3. Present situation and escalating hazards. Although the strait remains open, the region's volatility is increasing. The US-led Combined Maritime Force reports ongoing commercial traffic, but flags a high-risk environment, speculating that Iran may attempt to enforce a blockade. Such a move would severely disrupt global shipping and oil markets. Even without a formal blockade, ships linked to Israel or its allies risk being targeted, either intentionally or through collateral damage via mines, drones, missiles, or misidentification, as seen in Red Sea incidents involving Houthi rebels. 4. War risk clauses in English law charter parties. A central concern is how standard war risk clauses under English law, such as BIMCO's conwertime and voywar, apply in this perilous environment. 4.1 Activation triggers. A blockade by Iran would be considered a war risk under conwertime, allowing owners to refuse orders or demand deviation. Even absent a formal blockade, threats to attack vessels judged to support Israel may suffice to invoke war risk provisions. 4.2 Rights and obligations. Under conwertime, versions 2013 and 2025, masters or owners may refuse to proceed through any zone deemed dangerous, provided they give charterers notification. Owners can then request an alternate destination, and, if none is provided within 48 hours, 72 hours in the 2025 version, discharge at a safe port at the charterer's expense. The voywar clauses similarly offer refusal rights and, after a set notice period, 48 of 72.
4.3 Assessment of war risk. Owners' decisions must rest on a bona fide, objectively reasonable assessment of danger requiring inquiries, risk analysis, and possibly consultation with flag states. A key legal distinction is whether the charter party itself assumed those risks. In such instances, owners cannot refuse unless a qualitative change in threat has occurred. If a charter party explicitly states that transit through Hormuz is permitted, it may preclude refusal unless the level of risk significantly escalated after the agreement or clauses trigger the war risk framework. 5. Safe port obligations. Charter parties routinely include a safe port warranty, obliging the ship to berth at ports that are secure and usable with proper seamanship. Ships can reject orders to enter an unsafe port and seek alternatives. Persisting in directing the vessel to such ports can constitute a repudiatory breach by the charterer. A port's safety is judged prospectively at the time of ordering. Even if initially safe, a port may become unsafe before arrival, triggering a duty on the charterer to propose a new destination, especially under time charters. In the current scenario, with missile exchanges escalating, maritime experts may begin classifying transits through Hormuz as unsafe at this point, making safe port clauses increasingly relevant. 6. Financial measures, insurance and premiums. If owners proceed with the voyage, charterers must cover additional insurance premiums per conwertime, and provide proof in newer versions to deter inflated claims. They also need to consider contracting blocking and trapping insurance against vessel seizure or detention during prolonged blockade situations. 7. Recovering losses, damages and indemnities. If a charterer's orders force the vessel into danger, they're in breach of contract, potentially entitling owners to damages. Under appropriate charter forms, e.g., NYPE 1946. Owners may also claim indemnity for losses directly caused by following problematic instructions, though not for risks they had contractually accepted. 8. Contractual discharge, frustration and force majeure. 8.1 Frustration. A contract may be frustrated if unforeseen events radically alter the nature of performance, making it avoidable to enforce. However, war clause provisions often preempt frustration by outlining specific consequences for blocked passages or alternative routing. Proving frustration remains difficult unless oppressive delays or rerouting fundamentally change the contract's core obligations. Time and voyage charter terms differ. Voyage charters end with no hire or damages. Under time charters, payments stop at discharge, subject to equitable adjustments under the 1945 Law Reform Act.
8.2 Force majeure and cancellation. English law doesn't generally recognize force majeure unless specified. Whether a charterparty's force majeure clause is triggered depends on its wording. VOIWAR 2013/2025 allows owners prior to loading to cancel the charterparty in a declared high-risk zone, provided they give charterers notice and allow them an opportunity to nominate alternate safe ports. 9. Proactive advice for charterparties. 1. Prioritous safety. Although war risk clauses offer certain remedies, the crew's safety comes first. Any order that unduly risks life or vessel may be refused even absent clause coverage. 2. Conduct thorough risk assessments. Owners should take time to evaluate threats and consult experts before deciding compliance or deviation. Ensuring documented evidence supports their judgment is vital. 3. Maintain transparent communication. Cooperation between owners and charterers is essential in resolving routing disagreements or selecting safe alternatives. 4. Observe deadline obligations. War risk clauses impose strict time frames. Deviations, port refusals, and cancellations hinge on proper notice and timely responses. 5. Enhance future agreements. For trades likely involving Hormuz, parties should consider tailored war risk clauses or expanded provisions concerning insurance, premiums, and cancellations. Conclusion. The unfolding Israel-Iran confrontation around June 13, 2025 thrust the Strait of Hormuz into sharp legal focus. For shipowners and charterers governed by English law, maneuvering through war risk and safe port clauses, insurance responsibilities, and potential contract termination demands astute legal understanding and proactive risk management. Ensuring clarity in contracts and aligning operations with maritime security realities will be essential as the geopolitical situation evolves.